Welcome back to Illinois Law. We were talking about the consequences of entering a guilty plea. And before we left for break, Susan, you had mentioned about entering a guilty plea, the ramifications it would have, not just in the immigration arena, but also in the non-immigration arena, particularly employment or perhaps licensure. Could you speak a little bit about how entering a guilty plea would affect someone's licensure status in a profession?
Sure. People in certain professions, such as, for example, social workers or teachers, anyone who works with children, even lawyers, pleading guilty to certain offenses could lead to an inquiry or investigation into whether that person's licensure should be taken away or not. And
or even initially granted?
Correct. So that someone who, say, has just finished law school and they're applying to be a licensed lawyer, if they plead guilty to some offense while they're waiting for that to be granted, they should disclose to the licensing authority that that has happened. And so it's always a good idea to consult with a lawyer whenever there is the chance that there could be great ramifications beyond just immediately getting this ticket out of the way or immediately being able to go to court one time and have it over with. There could be things beyond there. And also, of course, the impact on a person's driver's license could be greatly affected if they've had a certain number of traffic convictions, in other words, guilty pleas, within a short period of time, particularly if that driver's a young driver. The license, it's the Secretary of State's office that has the authority to grant or take away a driver's license, and many people don't realize that the court system is one avenue where pleading guilty will have an impact, but beyond that, the Secretary of State will become aware of any guilty pleas as to traffic violations, and so there is that impact potential too.
So say a young person has pled guilty to, say, 2 moving violations, and their license under Illinois law would be suspended for a period of time, I believe it's 6 months. And then they go to apply for a job. They've graduated from school, and they fill out that first employment application for their profession, and they ask, have you ever been convicted of a crime? That person would have to truthfully say yes. How would you advise that client?
I would always advise the client when you're uncertain, the best approach is to disclose it. And the proper answer might simply be yes, but only as to minor traffic violations, or yes, only as to one offense when I was age 18. Will explain upon request, or something to that effect. The best course is always to be honest and upfront, which again leads back to our advice to always think carefully about what you are potentially doing to your career, your profession, your employability by entering a plea of guilty.
Now, Judge Edna, what if someone, it's not a petty offense, it's a little more serious, such as certain misdemeanors or a felony, and it's an individual that doesn't have the means to consult with a private attorney? Does the court system, would they be allowed to have a public defender, perhaps?
Well, I don't use the word allow. They have a right to a public defender.
Thank you for that clarification.
If they cannot afford an attorney. Now, there's an affidavit that will be completed. There'll be questions that will be asked, your income, who you support, where do you live, etc., etc., etc. And then there's a cutoff, I don't know it offhand, and if you're below that, then you have a right to a public defender, and the court will appoint an attorney to represent you. You never have to go in there by yourself because you cannot afford an attorney. And I've heard people say, well, I want a real lawyer, I don't want a public defender, which is just nonsense, because some of the finest jurists that we have in this county were formerly assistant public defenders. The present public defender, at least in Cook County, at one time was an assistant public defender. Then he became a judge for a number of years, and now he is the public defender. So that's nonsense. They're very fine lawyers, so it's not as if you're getting a lawyer, not getting a real lawyer. You're getting an excellent lawyer that's going to be appointed to you, and it is that lawyer's duty to tell you all the ramifications of a guilty plea. They should also advise you that you have a right to a jury trial. They should do all the admonishments that a judge would do so that an intelligent waiver can be made, that they don't want a jury and that they don't want a trial of any kind, and that they want to enter a plea of guilty. Now, there could be a number of reasons for that. It might be that the lawyer tells them, with all of this evidence that the state has, you probably will be found guilty, and I don't know what your sentence will be. But if you want to enter a plea of guilty, it's called a negotiated plea. They will talk to the assistant public defender, and they will work out some kind of, I don't want to call it a deal, but they will work out what your penalty will be. The court does not have to accept that. The court will clearly say, when you stand before them and decide you want to enter a plea of guilty, they'll say, I am not a part of that negotiation. Do you understand that? And then they will give the range of your sentencing. Then you have to make the decision if you want to proceed on without the court agreeing to the plea or not. So yes, if you cannot afford an attorney, I think that was your original
Yes.
question, there will be appointed on misdemeanor cases or cases where you can go to jail, an assistant public defender, who are very fine lawyers here in the County of Cook.
Thank you, Judge Edna. Now, Sarah, on the immigration issue, your practice consists primarily of family practice with immigration.
Family-based immigration and removal defense.
If an individual comes to you and has a certain immigration status and they want to enter a guilty plea to either a misdemeanor or a felony, how would you approach that?
Well, under immigration law, a person's status is very important. Either they are lawfully here on a valid visa or as a permanent resident, and they're subject to losing that status and being removed. On the other hand, we have people who currently have no legal status in the United States, but they may be eligible for legal status in the future if they don't have certain criminal convictions.
Oh, so that's very important.
Under
Yeah.
immigration law, convictions for crimes involving moral turpitude like theft, forgery, fraud, make someone inadmissible or deportable, which means they can't apply for legal status or they could be removed if they're here lawfully. And also aggravated felonies. It's important to remember that the definition of aggravated felony is different under federal immigration law than it is under state criminal law.
What is the definition under federal law?
It depends on the type of crime.
Okay.
So you could be convicted of a misdemeanor under state law,
Yes.
but for immigration purposes, it could be considered an aggravated felony.
Oh,
It's very important.
Right.
So the specific offense that an individual is charged with will determine whether or not there are going to be immigration consequences. And so if there's an opportunity to negotiate a plea, sometimes they can negotiate a plea to an offense that will not make them removable or hinder their ability to apply for legal status.
What about a petty offense such as a traffic violation? Would that affect their immigration status?
Generally, no.
Okay.
However, someone's applying for permanent residency, it's a matter of discretion whether or not to grant permanent residency. So someone with a very long history of traffic violations, that will be weighed against them when they apply for permanent residency.
That's interesting. Now, do you see a lot of people that have certain a certain status as an immigrant, that it's common for them to reach out to an attorney?
No, in fact, my experience with most immigrants is they don't understand immigration laws, although that's also my experience with American citizens, that they don't understand immigration law. Immigration law has said to be second only to the U.S. tax code in its complexity.
Oh.
So it's very complex, very difficult to understand. It's really, really important before a non-citizen pleads guilty to a crime that they inform their defense attorney that they're worried about their immigration status, that that's important to them.
In the Padilla case, the defendant indicated that he was an American citizen, correct?
No, he was
No?
a lawful permanent resident, and he'd been a lawful permanent resident for over 20 years.
Okay.
And so his defense attorney assumed, because he had been here for so long, pleading guilty to this very serious controlled substance offense wouldn't result in deportation,
Okay.
which is simply not true under
Okay.
our immigration laws.
Okay. Thank you.
Sure.
Now, Susan, getting back to the legal resident, the person who has citizenship or is here legally, and they enter a guilty plea and they are looking for employment. You earlier had indicated that it's best, if it's a minor traffic offense, to answer the question on the employment application that indicates whether you've been convicted of a crime. You say yes to a minor traffic offense. If it's beyond a minor traffic offense, how would you had indicated earlier about representing that, yes, one offense when I was, young or 21 or 18 or whatever it is. What if it's a more severe offense, a higher level of a misdemeanor or a felony? How would you advise the individual to approach that on the employment application? Because they ask that open-ended question, have you ever been convicted of a crime?
Well, the most important thing is to always be honest and upfront, because even if, let's say, the person says to themselves, well, I know, but that was a lot of years ago, and it was in another state far away, and I was using a different name at the time, that was before I was married, for example. Still, even if they get the job, some years down the line, somehow that may be discovered, and the person could then be fired on that basis, and then ramifications could occur from that. In other words, if they were in a position where, because they had lied on their employment application, harm was done to some of the clients, for example, or there were other consequences from them not being honest about that. An example might be if part of the person's job duties involved driving.
So sorry we're out of time right now. Thank you for joining us. This is Illinois Law.